Welcome back to Adam Bernard podcast. Today we're going to be talking about the new employment rights in 2026. I have Miss Seema here again with me. How are you?
Good, you?
Good. The first question I'm going to ask you is, what are the biggest new employment rights in 2026 that employees in London need to know about?
Okay, so really exciting. So the changes come through in April. Okay, one of the biggest ones is that paternity right is now a day one right, meaning that 26-week rule is now gone. So effectively, fathers can come in day one, give their employer notice that they're going to be on pat leave, expecting a baby, and that right will pass from day one. The other good thing is that low paid workers automatically qualify as well. This is all changing from the 6th of April, so it's already in effect now. Now, another big change is that as part of whistleblowing, sexual harassment is also a protected disclosure. So that's going to be a really good one. A new change that is going to be coming into effect in October is that usual 3 month minus 1 day rule for tribunal applications is now going to be moved to 6 months. So that's going to be really good for employees claiming unfair dismissal.
Amazing. How does day one paternity leave and parental leave work in practice for employees across London?
Okay, so what it effectively means is typically you have that 26-week rule that I mentioned earlier. So what that means is a father has to effectively be employed for 26 weeks before they can then give notice that they're expecting a baby. Now, if you take your employment on day one, you just need to notify whoever, your HR, your employer, your CEO, whoever you is your direct lead, and let them know that you're going to be expecting a baby, and effectively from that day you've given them notice, so you can go on pat leave the next day. It opens up a whole plethora for fathers to have rights, basically.
Okay. Seema, if I've been treated unfairly at work, how long do I now have to make an employment tribunal claim in 2026?
Okay, so like I mentioned, so at the moment it's 3 months minus 1 day. From October, so not from April where these new changes have come, from October you will have 6 months.
Mm-hmm.
So what that effectively means is from the date of the last incident, at the moment you have 3 months minus 1 day to file a tribunal application in ET1. From October, you will have 6 months. So from the last day of the incident, you will have 6 months to file a claim, which is massive because 3 months minus 1 day goes super quickly.
When should an employee contact the Fair Work Agency, and when is it better to speak to a London employment solicitor?
Okay, so another change that's come in with these April changes for the employment law rights is that this new fair agency has been created. Effectively, it's a state-backed government body that deals with violations such as sick pay, if you've been not fairly treated, things like that, labour violations. So in terms of when it is appropriate to consult them instead of a solicitor, I always say consult a solicitor first, okay? Reason being is because solicitors are obviously legally trained. Like ACAS, like unions, they're typically not, okay? So typically what I say is complex cases, always go to a solicitor. Anything kind of minor, you can consult the Fair Work Agency and they will be able to assist you. But things such as whistleblowing, discrimination, unfair dismissal, definitely solicitor approved.
What evidence should an employee collect if they think they've been unfairly dismissed?
Okay, so what's really important, unfair dismissal, what that effectively means, you need to understand what the term means. So unfair dismissal is when there has been a violation or a wrongdoing, okay? Examples of that, straight unfair dismissal would be if they're not giving you any maternity leave, paternity leave, things like that, okay? Always, what is the most important thing, you need to have evidence that supports your case. Minutes of any meetings, any grievances you've filed. If they're going through redundancy, for example, if they haven't done any consultations, you need to have supportive evidence. If you're claiming, that as a direct and proximate result, you've suffered physically, you've suffered emotionally, you need to have medical evidence to support that. Your claims are always going to be stronger when there's evidence. So any type of evidence that's going to support your case is going to be helpful.
So how have the time limits for the tribunal changed employees and the way they should handle workplace disputes?
Right, so as we mentioned, we need to focus on that rule, okay? So typically at the moment it's 3 months minus 1 day. From October it's going to be 6 months. So within that time, really simply, if the incident happened on, say, the 1st of January, okay, At the moment, you have 3 months minus 1 day to be able to go to ACAS, who are our independent body who deal with early conciliation. You need to have done that before you file a tribunal application, otherwise your claim will be meritless, unless there's strict liability for something, say, like abuse, harassment, physical abuse, okay? From October, from the 1st of January, you'll have 6 months minus 1 day. So that gives you so much time to be able to go to ACAS, mediate if you want to, seek, professional help, which I always advise my clients to do, and then file your ET1 application to tribunal.
What's the most common mistakes that employees make when dealing with the new employment rights, and how can they actually avoid them?
Okay, so turning to, and there are so many new rights that have come in. We touched on a few, one of them being paternity. So you have to, with the paternity, it's not an assumed right, okay? So what that effectively means is the day that you come in and you're employed, you have to still notify and give your employer notice. It's not assumed, okay? So one of the common mistakes is they don't give notice, they think it's assumed, okay? The other example is, for example, statutory sick pay. You will now receive that on day 1 instead of that 3-day rule. So typically what would happen is employees would wait 3 days before they're entitled to their statutory sick pay. Now it's on day 1, okay? You get it the first day that you receive that sick note. What employees, another, trap that they fall into is they don't immediately notify their employees that they're unwell, so they're not eligible because they haven't notified them. They just still think that day 1 rule is there. Another thing with these rules is that low paid workers also qualify. That previously wasn't there, so sometimes low paid workers think they're not eligible and therefore they miss out on receiving that payment. The other thing we touched upon was whistleblowing is now part of a protected characteristic for sexual harassment. That's amazing. So what that effectively means is, if sexual harassment has taken place, you must make a complaint. You must make a protected disclosure. That could be to anyone that you, HR, another colleague, it has to be known. Now that allows you to basically whistleblow that has happened, and you're safe and you're kind of protected under those new rights. So another trap that people fall into is that they don't make that protected disclosure. You must do that. You must make a complaint, whether informal or formal.
Brilliant. Thank you for coming on to our podcast. We missed you very much. If you have any questions about your employment rights, you can contact Seema. She will definitely get in contact with you. Thank you for joining us on our podcast. We'll see you in the next one.